This is a case so shocking. The district attorney working this case said she was horror-stricken when she first learned about it, and you yourself might need to brace yourself for the details in this one, because these two people you see here are facing charges after an 11-year-old gave birth inside their home. DNA results allegedly just proved that the girl's stepfather is the baby's father. How this case could be prosecuted moving forward, as so many people try to understand how this could happen. We're on the case, presented by Law and Crime. I'm Chris Stewart. There are no words that will be able to express just how sad this story is that we're following out of Oklahoma. It's certainly shocking, and it's not easy to hear. I'll warn you about that. It's not easy to talk about either. This story first came to light on August 16th inside this home in Muskogee, Oklahoma, which is about an hour's drive away from Tulsa. According to KWTW, who spoke to the district attorney prosecuting this case, an 11-year-old girl gave birth to a full-term baby in this house on that day. Now, here are the mugshots of the girl's mom and stepdad. Their names are Dustin and Cherie Walker. The DA told the TV station at first these two said they were also shocked by what happened because they claimed they had no idea that this young 11-year-old girl was pregnant. The district attorney pushed back on that, saying the 11-year-old was, quote, petite, so it would be pretty obvious if a girl that small would be pregnant for a full 9 months leading up to the birth of this child. They say happened on August 16th of this year. Now, we found old Facebook pages for this couple. Dustin is 34 years old. Cherie is 33. Many of the pictures show them holding young children. A neighbor to the couple told KJRH TV that 6 children in total, including that 11-year-old girl, lived in this home along with several dogs and cats. They say this was a very disturbing situation playing out in this home even before this young girl gave birth to a child. The neighbor said that this couple did not have running water in their house for the last 2, maybe 3 years. Now, at first, the Walkers were charged with 6 counts of neglect, and it appears that is a charge of neglect for each child living inside this home. But then there was a major development this week on top of what was already a major story. The paternity test came back on that baby that the 11-year-old gave birth to, and the district attorney told KWTW that the results show that the girl's stepdad, Dustin Walker, is that baby's father. He now faces a charge of sexual abuse of a child under the age of 12. Cherie is also facing an additional charge of enabling sexual abuse. Now, it doesn't appear that Cherie has a criminal history. We did find 2 cases in Oklahoma court records involving Dustin Walker. One of them is from 2020. He was charged with firing a gun inside his home. That case appears to have ended in what appears to be a fine of some sort, and records show that the case was sent to collections when the money wasn't paid. In 2023, Dustin was also charged, this time with domestic assault and battery in the presence of a minor, but that case was dismissed according to Oklahoma court records that are available online. Both the Walkers are now being held on $100,000 bonds. The DA told KWTW that both parents could spend the rest of their lives in prison if they're convicted, if these allegations that are so incredibly shocking are actually true. As for that young girl who allegedly gave birth inside this home, a home that didn't even have running water, according to that neighbor, the district attorney says that young girl is traumatized, understandably so. That girl had to give birth inside that home without any medical care. Allegedly, it was Cherie, the mom, who delivered the baby. But then EMTs were called, and that's how this situation was discovered inside this home. Not to mention, that young 11-year-old girl, according to the district attorney, had not seen a doctor in more than a year. She wasn't in school either. So there was no way that people outside of this home could have known that this was happening, at least that we know about. It appears that she was kept off the radar, because you think of whether she was brought to a doctor or to a school, people there could have intervened and could have helped. Instead, she was allegedly kept out of sight. Join us now to talk a little bit more about this story is Practice Professor of Law at Temple University, Marian Bracha. Great to always have you on Law and Crime. Such a difficult story we're talking about here. I know you used to work in a district attorney's office. You have prosecuted very difficult cases, but I mean, how common is something like this, because it's just, in some ways it is so shocking, but it's also just incredibly sad, the allegations here.
Unfortunately, we have no idea how common this is, because crimes like this go unreported and committed undercover, and they are committed in the darkness and in the privacy of people's homes. And so we really don't know just how prevalent a problem this is in certain communities, because of the very intimate and secret nature of how this abuse is perpetrated.
As we were putting this story together, we put both Dustin and Cherie Walker's name into truthfinder.com to try to learn a little bit more about them. Not only did Truthfinder show the address where that 11-year-old girl allegedly gave birth to a child, we also learned a little bit more about their history. Cherie didn't have a criminal history, but we did see the domestic violence charges against Dustin that stem back from a 2023 incident. Those charges were dropped, but helped paint a little bit more of a picture of his background. At Law&Crime, we partner with Truthfinder. We use it to get details on the people involved in our stories. But even if you don't work in true crime, this can be a great resource to give you some peace of mind, as it's one of the largest public record search services in the United States. And with the paid subscription service, you get access to unlimited reports about almost anyone. And by the way, right now you can get 50% off your first month of confidential background reports. Just go to truthfinder.com/OTC. Yeah, and it seems, at least according to what we've learned and what's being alleged, is that this young girl, 11 years old, was not in school. She hadn't seen a doctor in more than a year. So she was in many ways off the radar, and being perhaps allegedly kept out of sight, allegedly by these parents. As far as how this case could play out, they now reportedly have this DNA match to the stepfather, linking him as the biological father of the child that this 11-year-old gave birth to, this baby. What happens now in this trial going forward? Case.
Well, I think a lot of the evidence in this case will come down to the science. It'll come down to the medical records. It'll come down to the vital records to establish how old the complainant, when I say the complainant, I'm referring to the 11-year-old who was impregnated and who did deliver a live birth. So it'll come down to establishing how old she was on the date of her delivery, that the fact that the baby she delivered was full term, so doing the math, working backwards to establish how old she would have been when that baby was conceived, and then we establish a timeline for when the latest possible date for when the abuse would have started. That's what gets you the when I say you, the prosecutors, the statutory minimum for how old the victim was at the time of the abuse. Certain categories, certain subsections of the sexual assault charge go by how old the victim was at the time of the abuse. So doing that calculation and establishing that timeline will be very important. And then, of course, there is the other forensic evidence, the scientific evidence of establishing that the child that the 11-year-old delivered was in fact biologically related to her stepfather, or the defendant alleged of this abuse in this case. So that will be established by the paternity test, by the DNA testing. So a lot of the elements that will need to be met by the prosecution in this case can be met by records, by reports, by medical records, and by the DNA testing itself.
In so many of the cases involving allegations of sexual abuse, we'll see the victims take the stand, that they have to testify. That takes an incredible amount of courage. I know you've been in the courtroom for when that's happened. In this case, though, you have a alleged victim who is so young, who's 11, who's been through this traumatic experience. And you also have the science, the DNA that we've been talking about, that proves that Dustin Walker, the stepfather, is the biological father of this child. How likely would it be, if this even gets to a trial, that the prosecution would need that 11-year-old to take the stand?
Well, based on my understanding of the elements that need to be established, and based on my understanding of Oklahoma evidence, and in full disclosure, I'm not an Oklahoma practitioner, but based on my understanding of it, the prosecution would not need to call the 11-year-old victim to testify. They could establish and they could meet their burden to establish beyond a reasonable doubt the elements of the sexual assault charge, just based on what we talked about before, the records, the medical records, the birth certificate records, the records of vital statistics, the DNA report, the results of the paternity test. So they wouldn't necessarily need the testimony of the 11-year-old. And if I would hope that the prosecutor's office also has victim witness assistance and they have advocates for the 11-year-old, I would hope that some of the decision-making authority is being given to this 11-year-old, that she is empowered to make some of the decisions about her participation and cooperation with this case. Because up until this point, of course, these are allegations, but up until this point, I think a lot of her autonomy and decision-making has been stolen from her. So I would hope that the prosecutor's office is engaging in some empowerment to make sure that she has some decision-making authority.
The Walkers reportedly have said that they had no idea that this 11-year-old was pregnant. Clearly, with the paternity test, if that is true, that would be a lie on Dustin Walker's part. But then for the biological mom of this 11-year-old, Dustin Walker's wife, Cherie, she is facing this enabling charge. It does not appear that there's a lot that they kept inside that home that no one knew about until this girl gives birth. As prosecutor, what would you need to prove that she was actually enabling this in the home and wasn't someone who maybe was the victim of domestic violence? Was someone who was abused? We don't know because we weren't inside the house. I mean, what type of evidence would you need to actually get a conviction on an enabling charge in this type of case?
So the enabling charge, in my opinion, has a little bit more of a proof issue and is a little bit more problematic from a proof perspective. So in Oklahoma, a parent who this biological mother was, a parent or a caretaker, can be held equally responsible for enabling sexual abuse. But this would apply if the biological mother caused, procured, or permitted those willful acts of child sexual abuse against her 11-year-old. So it's not sufficient under the law to say that maybe she suspected that something was happening, that maybe she turned a blind eye to something suspicious. It needs to be proven that she knew or reasonably should have known that there were risks posed to this 11-year-old, that she was in fact being or could be sexually abused by the stepfather. And then again, there needs to be an intentionality element that the biological mother caused that sexual abuse to happen. So when we talk about whether or not the 11-year-old would have to testify, as far as I know in this case, there are no records or videos or other independently authenticated evidence that would be admissible to show what the biological mother knew or should have known without the direct testimony of a witness who was in the house or enduring this abuse.
We don't know. They're due in court next month, both being held on a $100,000 bond. But in that enabling case, and the only thing we know through news reports is that the couple had argued that they had no idea, that they didn't know that this very young girl was full-term pregnant and about to give birth, which I think when you just hear that, and the DA said, this girl was, quote, petite, which is, saying that it just doesn't, I think for a lot of people, they hear that and they're like, that's just not true. If you're a prosecutor and that's actually their defense, I mean, how do you attack that argument and break it down if this was actually to get to a trial?
Well, I would say, if anything, that claim that they had no idea that she was pregnant supports the neglect charge. Because if the 11-year-old was built the way the prosecutor described, she was petite, she was, I have a 13-year-old and an 11-year-old, and I can envision both of their bodies. You notice the changes in their bodies because they're happening so rapidly, especially in that prepubescent stage. And so I think, if anything, that is supportive evidence of the neglect charge because it goes to show that she wasn't going to school. No teachers or guidance counselors or other school administrators or social workers were seeing a change in her. There were no social services coming to the house to observe changes in her. There were no doctor's visits or pediatrician visits that would show any change in weight or change in body shape or the onset of puberty. So it just goes to show that over this length of time, and if the child was born at full term, over this length of almost 40 weeks, there was no care and no other adult paying attention to the changes in this 11-year-old's body and in this 11-year-old's life. If anything, that is just further support and further evidence for the neglect charge.
And speaking of the neglect charges, because I think that's also a big part of this. I mean, you have the horrific allegations related to the oldest child in the home who's 11, but there's 5 other children who live in this house. And there was a neighbor who said this house hadn't had running water for 2 to 3 years. And we'll see how true that is. But and I know there's parts of this country that people are not fortunate enough to have running water every single day. But then at the same time, you say for these young kids to grow up in an environment that just seems to be very, very severe squalor. In the eyes of the law, typically, what is the bar for what is considered neglect, as opposed to just growing up in a very difficult reality for many people, especially in rural parts of the country where they just don't have access to things like running water?
Right. I think the law does take into consideration the very unfortunate disparities in socioeconomic statuses that exist in Oklahoma and in all parts of the country. So in order to establish the felonious neglect charge in Oklahoma, the neglect has to be willful or malicious. So it's not just the result of parents or caregivers who are of lesser means or who don't have access to certain supports or certain, I'll go so far as to say luxuries. But the law in Oklahoma does cover a broad range of scenarios where a person who is in charge of a child's health and safety and welfare, like a parent, a guardian, even a step parent, would willfully fail to provide adequate care. So again, we're going back to establishing an intentionality. So there has to be, for reasons beyond poverty, an intentional lack of proper care, like adequate food, clothing, or shelter, or sanitation, or hygiene, or appropriate education, like the child not going to school or being homeschooled for at least a year, not being seen by medical or dental or behavioral health professionals, not having sufficient supervision. So these all come down to, again, the intentionality of what the caregiver, the parent knew or should have known, and then was willfully, intentionally neglecting to provide to that child.
It's defense attorney's not an easy job. Everybody deserves a defense, but if for a defense attorney who would take on, maybe it's a public defender, whatever it may be, for Dustin Walker, and you have this DNA test that links him to a child given birth by a child, which is just so awful to think about. Like, what is his defense if this go? Like, how do you handle this case? I mean, does it even go to trial, I guess, with how strong the evidence appears against him?
Well, I can't answer that because, of course, every defendant has an absolute right, constitutional right, to confront his accusers and has an absolute right to go to trial. So I'm sure that the defense attorney who takes on this case will have a full and candid conversation with the defendant about what his various options are, what possible outcomes would be to any of those choices. So I would say if the case did go to trial at this point, with the science that exists, the forensic evidence that exists, probably the biggest argument or the most effective defense would be to argue the science, to say that there is that very slim margin of error in the DNA testing and the paternity testing that leaves open the possibility that he's actually not the father. They could certainly argue the admissibility of the other records that we've talked about, things like birth records or medical records, for lacking authentication, for the appropriate foundation that would be laid to establish those records as admissible in court. And so this really does come down not so much to factual arguments or emotional arguments about the righteousness of these actions or the propriety or even the mistake of age, because that defense doesn't exist in a case with a child this young. But they really would come down to the more legal, almost administrative arguments, like the authenticity of the records and the veracity or reliability of the science that would be presented in the form of the DNA testing.
When it comes to excluding evidence, because and very, very different case I'm referencing, but in the Idaho case with Brian Koberger, they tried to exclude the DNA evidence that had linked him to it. We've seen in the past that, the argument of, well, DNA, it might be some shaky science that the defense attorneys have tried to make. What is the bar that you would have to reach to actually get something like a paternity test excluded from a trial?
So that's a great question. So it comes down to the rules of evidence. It's in Title 7 or Chapter 7 of the Rules of Evidence regarding expert testimony. And there are two standards for expert testimony in court. Oklahoma follows a case called Daubert, and the standard there is reliability. So the question is going to be, is this reliable science? Is the opinion, when I say the expert opinion, I mean the person who analyzed the DNA results, looked at the sample from the 11-year-old and looked at the sample from the defendant, her stepfather, and compared them and did the math and did the forensic analysis to determine that there was whatever percentage chance there was that he was in fact the father. They would have to do what's known as a Daubert challenge to say that that science was not reliable and that the person who was doing that analysis didn't have the sufficient expertise to render that opinion. And so it really comes down to the judge, the trial judge in Oklahoma, being the gatekeeper for that evidence and determining whether or not it's reliable enough for a fact finder to consider.
And then just lastly, for this young girl who has been through so much based off everything we've been told and the allegations in this case, at just 11 years old, I mean, she's not, I would just say, old enough to be able to care for a child. I mean, she's still a child herself. What could happen to her? I mean, especially if there is not a family, we don't know if there's some distant relative that could come in, but if there isn't, I mean, what's the case for her, but also this baby?
The only thing I can say to that is, I hope that she is being provided the supports and the social services that she so desperately, clearly needs. She needs a safe and supportive environment in which herself to grow and to develop and to be able to make informed decisions, because clearly that has not been her experience, at least for the past year. And she needs to be in a place where she can very clearly consider what her future can be or would be if she wanted to be a parent at the age of 11, or what other options exist for her at this point. I would think that if there is no immediate family or family support who would be willing to take her in, take her child in, take her siblings in, that this would be a situation where the Oklahoma foster system comes into place, and hopefully she can be provided a safe placement and supportive placement so she can make a decision regarding her future.
Yeah, no, it just, what a very difficult story. Marian Bracha, practice professor at law at Temple University. Thank you for taking the time to be with us to talk about it.
Thanks, Chris. Good to see you.
The Walkers are expected in court next month. That will do it for On the Case, presented by Law and Crime. Subscribe to us on YouTube and Spotify. I'm Chris Stewart. We'll see you next time.